3, 2, 1. I'm sorry, give me that one. I don't understand what happened here. Okay. This is Judge Hoffman in the 68th District Court. We're here on the case, Renisha Gamble case, cause number DC 1814328. We're here on a motion to compel, motion for summary judgment, motion for leave, and I think the motion for continuance has been resolved. Counsel, please make your appearances.
Lauren Jobin for the plaintiff, Renisha Gamble.
Jeffrey Strauss for all defendants.
Okay, so let's kind of chat about, I think the first thing we were going to discuss is the plaintiffs filed a motion to compel. The parties have conferred pursuant to my instruction and have limited the scope of this motion to compel. I think there's also an issue involving a motion for protection. So why don't you guys go ahead and let me know what's still needs to be resolved on the motion to compel.
Okay, Judge, initially on so the driver is Kevin Hogan. On the interrogatories that were sent, which was attached as Exhibit A to our motion, if you go through, it's 19. Interrogatory number 19, which is in the whole document, it'll be page 6 out of 43.
I don't think that's been scanned yet.
Okay, it'll be in the last one too.
Let
if
me
you
see.
want me
Okay.
to, yeah, let me see.
Yeah, why don't you share screen it?
Oh, I've got it on my computer. So this is my iPad.
Oh no.
I'm not sure if I'm able to do that. Let me see. I don't think I'm able to do that when I've got them both separate like this.
Let me see if I can do it.
Let me find. If I open up the original one, I can just tell you what the one that you should have from before. I can tell you what the page number is that way.
All right, I need to open it up. Give me a second.
Okay.
Why don't you just read it for now, and then I'll.
Okay. Okay, here, I'll read it. I'll read it to you. Hold on. Okay. The first one is 19, and the question is, if it is your position that you were not negligent, please provide each and every fact that supports your answer, identify all witnesses who you believe will corroborate your position, and identify all documents that support your position. I understand, and we talked about this one. I said I'll limit it to just identifying, because it is disputed liability, to identifying any witnesses or who it is, or that would support that because it's a lane change collision, right? But we still can come to an agreement. And the objection objects that it's overly broad, unduly burdensome, to the extent it requests that things be specifically and in detail. There is no provision requiring party to state anything in detail. The question doesn't say in detail, so I don't know what that's about. Defendant further objects to this interrogatory to the extent it impermissibly seeks to limit its trial testimony. Defendant further objects that it exceeds the proper scope of written discovery as it attempts to take defendant's deposition by way of interrogatory. Defendant further objects that this exceeds the proper scope of written discovery. It requires the responding party to marshal all that's available proof or the proof that the party intends to offer at trial, and then they don't answer. And most of the objections are kind of similar, so.
Well, 20 is basically the same thing as well.
Yeah.
Judges ask for each and every fact that supports our legal contentions. It's also asking us to identify each and every document that we plan to rely on at trial, anything that supports our defenses and our legal positions. We don't think the Texas rules provide proper interrogatories to force us to marshal all our evidence. At this point, the discovery period is ongoing. We still have several months for discovery. We just think both of 19 and 20 are overbroad, improper interrogatories in general. I offered to, if opposing counsel wanted me to just refer to all persons with knowledge of relevant facts and the fact that we're going to be relying on documents produced in evidence or impeachment evidence, I would do that. But we still couldn't come to agreement. So basically our opinions, our position on 19 and 20 are that these two are just vastly overbroad. They're asking for each and every fact, each and every piece of information that we plan to rely on at trial, and each and every document that we will rely on to support our legal positions.
Can't hear you. We can't hear you.
Oh, can you hear me?
Now I can.
Okay, Judge, I mean, our position is that, I mean, no witnesses have really been identified other than the driver essentially, and these questions kind of go towards that kind of information. So, I mean, once we get through the other, I mean, that's what we're asking. And I agreed to, you know, whatever documents, because it is disputed liability, I think that they should have to answer it somehow. I don't think you can just blanket make these objections and not answer anything.
I do think 19, can you guys hear me now?
Yes.
Yeah.
Okay, I think 19 is overbroad, even with the limitation. Let's see, 20. Yeah, I think 19 and 20 are just overbroad. What else do we have?
23.
Oh, Lauren, I supplemented 23 this morning.
Okay. Okay.
Basically said we weren't making that contention that Hogan is not a proper party to the suit.
Okay. Then if we
pursuant to our conversation that we had on Tuesday.
Okay. Then the next one would be in request for production, which is Exhibit B, 28 and 32, and that will be on page.
Are you guys able to see what the
Yeah.
screening? Okay.
Yes, sir.
I'm new at this share screen thing. It's kind of a cool feature.
Well, I found myself trying to navigate that screen, but realized it was you and not me.
Yeah.
I don't know if you can do anything.
No, I don't think so.
Okay.
Okay. So you're almost at, yeah.
Is that it? 28?
28. Yeah, a copy of the ISO reports or documents regarding plaintiff.
Okay, so explain, I'm not familiar with that term. What is an ISO document?
A lot of times, a lot of other companies, they just produce some Geico. It's like a claims history that they run on the plaintiff regarding any other kind of claims. So if it's an ISO report or document, it would be any documents that they would have stating, you know, that she made a claim for property, whatever it is, any kind of documents like that, that they would produce those to us. I've had counsel produce them all the time. I mean, it's never really been an issue, but Jeffrey's position, I think, was that, what was that it was proprietary?
No, position is that I represented that we don't have any responsive documents to this, but as written, anything that would be generated that we responsive to this at this point would be privileged as attorney-client or work product information and material.
Well, and my response to that is that ISO reports is a service that you can purchase, Judge. It doesn't have to be created by Fee Smith. You can just purchase like, you know, trial reports or whatever it is and run those. So, I mean, it's not generated by Fee Smith.
The objection request 28 is overruled, so you're gonna have to answer that. What's the next one?
32.
All right.
Which this was social media stuff.
All right, yeah, that's definitely overruled. So you need to produce that.
Okay, now request, let me see, on the next one, Exhibit C, it's 2 and 3.
Exhibit C. Okay.
Yeah, there you go. 2 and 3.
2 and 3. This is as to a different defendant, I assume.
Yeah, this is the actual trucking company. Now, 2, I'd had well, once you get there, I'll tell
see
you
it?
what. Yeah, let me see. Yeah, if you go up a little bit, there you go. This one, I'd said, I'd agreed to limit it to lane change collisions, so that's substantially similar, because this is a lane change collision, but we still couldn't agree.
Response?
Yes, Your Honor. Our position is that this is overbroad, doesn't seek anything that's relevant to our case. As we discussed, as opposing counsel and I discussed, this information would not be relevant unless the information was substantially similar and the accidents were substantially similar. This interrogatory does not include that information.
How big is this company? How many drivers do they have? Do you know?
They're
one
really
of the
big.
biggest in the country.
Well, and I
So
said we could limit it to Texas, Judge, too.
All right, so the court is going to allow this for the previous 3 years, lane changes, accidents in Texas. So.
And the next one, Judge, is 3.
It's
So just one right beneath that.
I'll limit that to, yeah, that's fine. Limit it to lane change cases in Texas.
Okay, and now if you go to Exhibit D, this is where the majority of them are.
Oh, okay.
There's a lot of them, but we'll be going one by one through them. So, I mean, it's 1, 2, 3, 4, and 5 to begin with.
And Your Honor, if I may, as background, when opposing counsel and I talked, instead of going through each one of these, I proposed that, I indicated that basically we have a lot of training materials, information regarding Landstar's policies and procedures. We believe all that stuff contains proprietary and confidential information that was developed pursuant to their business and involves business strategies that should not be able to be disseminated or disclosed outside of this litigation. That's the basis of our confidentiality agreement. It's, in our opinion, pretty straightforward. And I think that if such an agreement was signed by plaintiff's counsel, it would cover a lot of these disputed requests for productions. And in that confidentiality agreement, our burden would be, if we think that something's confidential, we would mark it as confidential. If there's a disagreement as to whether or not it's confidential, opposing counsel would merely indicate that, and that would shift the burden to us to prove how it is confidential. I don't think the case law provides that we are under a burden to prove that it's confidential from square one. I don't think that's what the law says, but it's clear that the training manuals, the information regarding Landstar's policies and procedures all contains information that should be confidential, should be held confidential in this case, and limited to only the attorneys and the people involved with this case, and not allow it to get outside of this case, if indeed it is confidential and proprietary. So we didn't go through each and every one of these requests.
Right, and I went through, and that's what in the amended, I mean, I can tell you which ones I think could maybe borderline. I mean, I've got them listed. When we get to them, I have them bolded, but I mean, these ones, policies regarding, I mean, agreements between people for indemnification for damages, I mean, that doesn't have anything to do with confidentiality. I mean, 3 doesn't have, I mean, a lot of these, and they did produce, you know, over 500 pages of stuff. So, yeah, I mean, I agree.
About 2,000 pages in this case already.
Yeah. So, but I still think we have to
I'm
go
not sure.
through these.
So can you guys hear me okay?
Yeah.
Request for production 1. I'm not sure I really all policies of defendant regarding driver disciplinary actions for accidents and tickets received by driver from 12 months prior to the accident to the present. What do you mean policies? Like insurance policies?
No, like policies, like what their disciplinary action policies are. If somebody's been in an accident or is ticketed, what's the driver disciplinary policy that they have in place at Landstar?
Okay.
Like,
that makes a little sense. Okay.
Yeah.
So that is overruled, and I'm going to find that is not confidential. So what's the next one?
2,
I'm going to overrule that one and also find it's not confidential.
3,
Overrule that one and find it's not confidential.
4,
I'm going to overrule that one. Well, there may be privilege issues potentially on that one. Is there privilege assertion?
Yes, Your Honor.
attorney work product, yeah.
Yeah, except to the extent that there's, I would instruct the defendant to provide a privilege log if they're asserting a privilege. And for those documents that aren't privileged, I'm going to overrule the objection and find it's not confidential.
5, and I'll agree to limit that if.
I'll limit it to the last 3 years in Texas for lane change cases. And I will find that the settlement agreements are confidential,
Okay.
not the petitions.
Not the what petitions?
Yeah.
Petitions, not the petitions or anything. All you're going to be required to produce is the petitions and the settlement agreements for the last 3 years for cases in Texas arising out of lane change cases. The settlement agreements will be confidential. The petitions will not. You don't have to produce anything else.
Okay. 7.
7.
Yes. And that could be limited to Texas too, Judge.
I'm going to limit it to the extent it's different than what we had before. I'm going to limit it to the last 3 years to lane change cases in Texas for the previous 3 years, and and this can be confidential. You can list this as confidential.
Okay. 12.
I'm going to overrule this objection to except to the extent there's any privileged documents. If there's any privileged documents, you'll need to create a privilege log and provide that to the plaintiff. And I'm going to find that this is not confidential.
13.
All right, that's really broad.
Mm-hmm.
Yeah, that's just too. Did you object to overbroad?
Yes, Your Honor.
Yeah, I agree. That's vague. I'm going to sustain that one.
Okay. 15.
That the court will find that is confidential, but you need to produce it, and the objection's overruled.
Okay, 19.
The court will find that is confidential, but you order it to be produced, and the objection's overruled.
20.
I'm going to overrule the objection. I don't know what that would be exactly, so if you're going to have to make that determination if it's confidential or not. I just don't know what's going to be in there.
Okay, 21. I mean, really what we're,
broad.
I know, I mean, I can limit that to just policies and procedures regarding say driver standards and hiring requirements.
Still, Your Honor, what does that, I mean, what does that even mean?
I mean, they're hiring criteria. What are their requirements in order to be able to operate a tractor trailer and on the roads in Texas?
For hiring requirements?
Yeah, standards for drivers that are in their employ.
The court is going to overrule, I'm going to allow that limited discovery and overrule the objection, but we'll find that's confidential.
Okay, 23.
I'm going to overrule that objection.
25.
So we went past that.
Judge, can we go back to 23?
Yeah.
As written, that doesn't necessarily just, well, as written, it doesn't include only the incident question.
Oh, well.
Is the court's ruling that any tests at any time regarding Mr. Hogan are to be produced?
Response.
Your Honor, I mean, we filed a motion for leave to add gross negligence. So if there's a situation where the company has had knowledge that he's had toxicology tests, that he's failed, given what I found on SAFER and FOIA, and the fact they've had 420 wrecks, and they have a lot of violations for that very specific behavior, I think it is relevant. I think it's relevant.
This is just for Kevin Hogan. I'm not allowing you to go into this for other drivers, just for Kevin Hogan. That's okay for, if he has a history of failing drug tests and you kept him on the employment and he failed it again, that would be potentially relevant.
Just to be clear, Mr. Hogan's deposition has been taken. There's no suggestion or even inclination that that's the case in this case. Just correct. Mr. Hogan has a stellar driving record.
Okay. There won't be any, I'm sure. Won't be any failed ones then.
25
What's
is,
the
I
next?
mean, 25, Judge, with, yeah.
That's just for the date of the collision?
Yes.
Okay. Yeah, just for the date of collision, that's overruled.
26.
That's overruled.
27.
Overruled, except to the extent there's a privilege.
28.
And then a privilege log would have to be produced. 28.
Yes.
Overruled.
29. Oh, it's gone.
Overruled.
33.
I'm not sure I understand that question. All memorandum or other similar documents that sent to Kevin Hogan.
They have been about 6 months after this incident. They were given a critical warning from the Federal Motor Carrier Safety Administration for operating for hours of service compliance.
Not for Kevin Hogan.
So, and I mean, this is for, I mean, I think it's relevant as to the trucking company and what kind of drivers that they're hiring. And I mean, it is specifically relevant given the fact, I mean, it's in the FOIA documents. I mean, they were in a lot of trouble for that. So if they have documents about that, I think I'm entitled to look at it. And I think I'm entitled to ask questions of whoever they designate as their safety,
but I guess
representative.
My question is, these are documents sent to Kevin Hogan, like if he was being disciplined or memos regarding.
Yeah.
Exactly
if there was any issue with, yeah.
So they're wanting every piece of information and document that Landstar has ever sent in the history of Landstar to any driver that possibly includes any information regarding falsification of logs and driving over the
No, it's just
limits.
Just to Kevin Hogan.
It's just sent to Kevin Hogan.
Oh, no, it says and or any all other drivers. It says,
Okay, I'm sorry. That part is cut out. I can't see that. So yeah, that would not be for all drivers. That would just be for Kevin Hogan.
Okay.
Yeah, to the extent it's for other drivers, I agree with Mr. Strauss. That's too broad. But for Kevin Hogan, anything sent to Kevin Hogan about that.
Okay. 34. And this should be just for Kevin Hogan's. Yeah, I mean, I can do that for
relevance on any documentation regarding any fuel receipt, recorder, or fuel credit card, or any other similar system for paying for fuel on trips for 6 months preceding this incident. What's the relevance there?
I'll limit that to, I mean, I can do.
What does that have to do with anything?
Well, I mean, it's to see how he's traveling and where he's going to and when he's refueling and the time it's taking him to get from one place to the next, given the issues with the hour of service compliance. So that's how it's relevant.
Well, we produced the logs in this case for the relevant time period, and there's no indication.
Logs can be forged. I'm going to allow it for 1 month prior to the accident, just for Kevin Hogan.
41.
We'll withdraw the objections on that one. There is none.
Okay.
Okay, 51. So this is all just related to this specific trip that he was on at that time. I know some stuff has been produced, but not all of it. I mean,
we've produced everything that we have.
That objection's overruled.
52.
I think it's duplicative. I'm going to sustain.
Okay, 53. Yeah, I mean that's what they determine to be a preventable. I know like FedEx, for example, has different standards as to what they consider preventable.
We don't know how that's relevant to this case.
I think it's very relevant to this case. So I think it's relevant.
Well, just saying it's relevant doesn't mean it's relevant.
Okay.
Well, I guess our argument, Judge, is the way that they did a post-accident investigation and how they review, you know, after a crash happens and there's an injury reported on whether it's preventable.
I'm going to allow this for the 3 years prior to any procedures in place in Texas for the 3 years prior to this accident. And you can't potentially designate this confidential.
Okay, 54.
Oh no. Oh, I hit a button and it all went away.
Oh, I have it still. You just don't.
Let me see. Oh, let me see. No, let me see. Now what do you see on the screen? Is that do you see my email box?
No, I just see request number 54. Is that what you see, Jeff?
Yep. I see the same thing that was up there before.
Yeah.
It might be frozen on our end.
Let me see. Okay. All right. Now I see it.
Okay. Yeah, it's 54.
All right. Got to be careful with those buttons. Okay. What number are we on? 54. Okay.
54.
What exactly in this context is a certificate of authority? What is that?
I think it's, you have to have you have to meet certain standards to be able to operate, interstate versus intrastate.
Okay.
And they're everywhere. I mean, they're all over the place.
Your Honor, the fact that Landstar Ranger, there's no dispute that Landstar Ranger has interstate motor carrier authority in this case. As written, this would include any license, any permit that Landstar Ranger has. You have to have special permits to transport hazardous material, go over certain bridges, go over certain underpasses. You have to have permits to do all that stuff. As written, there's no dispute that Landstar Ranger has interstate motor carrier authority.
I'm going to sustain this one.
Okay. 55.
Is there any question that this is the right defendant?
No, not now that we've already talked about that. So I guess 55 is okay.
Yeah, sustained.
These questions are kind of regarding the weight and things like that. I don't know if they have this stuff, but I mean, I think that just objecting to it, saying
isn't that covered? But wasn't that covered by your previous question? You had that one that had like 10.
50. Yeah, I'll withdraw 56. I think these next couple questions, 57, I'll withdraw. 58, I'll withdraw. 59, I'll withdraw. 61, I'll withdraw. 62, I'll withdraw that one as well. 63, same thing, I'll withdraw. 64, I think 65. No, 65 I want to still have.
Let's look at 65.
65 is regarding what the vehicle was outfitted with, the kind of brake system, because there have been some fault codes that I've identified that have come through VIN trucks on this particular tractor trailer that's showing that it has some critical failure. So I want to see what's with the brakes on 65.
Your Honor, the whole file that's maintained regarding the tractor and the trailer in this case.
I'm sorry, you cut out there, Mr. Krause.
Yes, Your Honor, we already produced the whole entire maintenance and repair file regarding the tractor and the trailer. So
I'll sustain this objection.
Okay. 60, and I will say, Judge, I mean, it's over 500 pages and I just got it 2 days ago. So some of them I may not have caught. 71.
Okay.
Is the next one.
this is
Objection. Yeah, I'm going to overrule the objection here.
Okay, 74.
Now, except to this, then you have some kind of privileged documents, and then you need to produce a privilege log.
understood.
What's next?
74. Okay, this I need to have a conversation with. Something has happened in this case. In 74, I added, so we received DWQs last year, and I spoke with Morgan McFeeters, who filed a motion for protective order in my case when we have appellate counsel in-house at Witherite for DWQs that were sent on 12/31 that contained all these Inree Cypress questions. And we requested that any DWQs they'd had answered be produced to us. We were not served on those DWQs. They went to Shelley Jock at the law office of James Lawrence. I don't know how we want to deal with that, but they're not valid DWQs if they're not served on counsel of record. But I do know from calling the record service that at least one provider did answer those questions. I don't know what they answered, but that needs to be produced to me.
Your Honor, this particular request says all depositions by written questions obtained by way of authorization signed by plaintiff. We don't have any authorization signed by the plaintiff. All the records that we've received in response to DWQs have been produced pursuant to the rules. We're not hiding anything. What counsel's referring to is a potentially improper service issue that's not before the court at this time.
Okay, I just wanted to make sure we address, because I still don't have whatever was produced to you guys, because I never got copied on the DW. So I just know that I thought it was the same kind of a question because it's asking for copies of all DWQs. So I just wanted to make sure.
This one says
That's-
by way of authorization though. But
Okay.
in any event, it's our practice to produce what we receive in response to DWQs, aside from the fact that opposing counsel would be copied on anything that we receive, have an opportunity to receive copies of it that way too. So,
Okay. Okay, then that's fine. 76 or 75, yeah, 75 is expert discovery.
Yeah, I just don't think this is the proper avenue to seek expert file materials. That is covered under request for disclosures. And as written, this would include.
I'll sustain 75.
Okay, then it probably 76 is probably going to be the same. Let me see. 76 is I don't know, is a production that relates to that interrogatory request. Yeah.
So that you would, that was the same as the other
Yeah.
defendant. So I'll overrule that.
Okay, 77. We only have 3 more. 77. Or no, 77, 78, and 79. So 78.
But what's
Yeah.
the next one? 77 or 78?
78.
This includes expert files, anything that any witness is going to be relying on. It's incredibly overbroad.
Oh wait, so
I'm
this
really
is,
just
what number are you talking about? 77 or 78?
78.
Oh, I thought we were on 77.
No, I think we're on 7. Wait, maybe I've gotten mixed up. What's 77?
Let's talk about any publication, study, guideline, document, manual, treatise, report, survey, textbook, pamphlet, or other literature that your expert or any other person designated as person with knowledge of relevant facts has cited or rely on.
I'm just looking for any publications that Peter Philbrick has in that, I mean, we can limit it to.
Well, that would be included in his expert file. That would be responsive to a request for disclosure.
Okay, have y'all produced that in response to disclosures?
As I sit here today, I can't answer that.
No, it hasn't been produced. So if y'all want to supplement your disclosures, then we can. That'd be fine. But I know I haven't seen anything like that. I've seen his report, but that's it.
77 is sustained. I looked at 78 as well. That's overruled.
And then 79. And then that's it.
I think we've already done that one, but okay.
Yeah, it was for the driver. I think this is for, yeah. And then that's all of it.
Okay.
And so I guess if you want.
So the next issue, I guess, is the motion for leave. Is that correct?
Yes.
Okay, let's deal with that next.
Okay, hold on. Let me get it up. Hold on. Got too many things open right now. Yeah, I mean, the situation is, Judge, is that we're asking for leave to file, to amend our petition and add gross negligence because based on there is testimony in the case, and obviously I'm about to get a ton of discovery that we haven't had after we've had this hearing. So I'm asking for leave because the deadline's run, but I didn't have all the documents that I would need to properly determine whether or not there's a gross negligence claim. Now, I think that there is evidence to support that in the case already, based on the fact that we've taken the deposition of the investigating officer, and there was also a witness that also is an 18-wheeler driver, and their expert is saying it's fine to drive in that left lane. But I think certain municipalities state that you're not allowed to travel. Trucks are not to be in that left lane. And the investigating officer testified that they were not in that area. He was not supposed to be in that lane. And then the other truck driver who actually gave a statement on the 911 call, there's a transcript, and then he gave a recorded statement. He's driving another 18-wheeler and testifies that this guy goes speeding past him and was going far too fast for the circumstances, and that he watched him get over and cut over in that lane. So that, I would argue, combined with the fact that I'll now have an opportunity and we have an additional 3 months and I can actually take the safety, their corporate representative's depot to explore, I would ask that I have leave to amend to add gross negligence so that I can further, I think their discovery is ongoing in this case too.
We recently changed the trial setting on this, right?
Yes, we did.
I'm going to grant leave to amend. What do we have next?
We had 2 MSJs filed on behalf of the defendants. Those were filed on behalf of Landstar System Holdings, Inc. and Landstar Ranger, Inc. I don't want to know what Lauren's current position is on Landstar System Holdings, but she removed the disputed discovery to them in the amended motion to compel. So I don't know if she's contesting that. Our basis for summary judgment as to Landstar System Holdings is that they're not a proper party. They had nothing to do with the operation of this tractor trailer. All that was done pursuant to motor carrier authority of Landstar Ranger. We filed a verified denial in that regard as to Landstar System Holdings. So, I mean, that would encompass that party as a party at any point in this lawsuit, including the respondent superior, the negligent entrustment, and the negligent training and supervision claims, which were all of plaintiff's claims against that party.
And so I'll briefly respond. I think that's accurate. And so long as it's clear that we have that, as long as Landstar Ranger is in the suit, then that's the correct party and we don't need them in. Because the only thing that I thought was a little weird is that they have 2 DOT numbers, and some wrecks are reported under one DOT number and others are under the other. So I just wanted to make sure that Landstar Ranger and letting out Landstar System Holdings, just if we can be clear on the record that this is a correct party, because I do agree with you, Jeff. If that's the situation, then I'm happy to let them out. I just want to make sure, this isn't a situation where it's all of a sudden, well, they're also a relevant party and they could share in some liability on this deal. If Landstar Ranger is the only one liable, then as long as we have that understanding, I'm fine letting them out. I'm not going to fight that MSJ.
All right, then I'll grant those MSJs, interlocutory MSJs. Anything else, guys?
Well, there is one more MSJ on Landstar Ranger. Now, that entity was the one who Kevin Hogan was driving pursuant to their authority. We're contesting the negligent entrustment and the negligent training and supervision claims as far as they're concerned, but we're not contesting the respondent superior claims. We're saying that in this case, the MSJs, as to those causes of actions, those limited causes of actions are proper because the evidence shows Kevin Hogan is not unlicensed, he's not incompetent, he's not reckless. That would take care of the negligent entrustment cause of action. And there's no evidence whatsoever to support a negligent training or supervision cause of action. They've taken the deposition of him. He's got a stellar driving record. He's gone through the proper training. He's got no violations of any federal safety regulations. And furthermore, Your Honor, this hasn't been even said yet in this case, but Kevin Hogan's tractor was equipped with a dash cam. So all the facts that are relevant to this case and this accident are shown on dash cam footage. It's going to show Kevin Hogan's movement. It's going to show how he passed slower moving vehicles. It's going to show the plaintiff driving in her vehicle way faster than our driver was traveling, and that she sped up and entered this lane as Kevin Hogan was changing lanes back to his right at the same exact moment. There's no dispute on what happened because we have actual video footage of what happened. So the basis of the MSJ for Landstar Ranger is that they cannot be liable for negligent entrustment. He wasn't unlicensed, he wasn't incompetent, he's not being reckless, and he wasn't being improperly trained or supervised. There's no evidence to support those causes of actions, and that's the basis of our motion.
Response?
Yeah, Your Honor, I'll address each one separately. Well, first, as the negligent entrustment claim goes, well, obviously I'm just now about to be getting discovery. So before I say anything about that, I think it's premature. Discovery's ongoing, and I don't think this is an appropriate time for that. I think the MSJ is, you can't not give me documents and then say I don't have evidence. That doesn't make any sense to me. So just before, on that note, then the other issue that I have with Kevin Hogan is we do have a peace officer and another driver of an 18-wheeler saying that they think he was doing something he wasn't supposed to do. So that is some evidence, right, for the trader of fact to look at and say, well, maybe that conduct, they did negligently entrust him with that vehicle, because those are things that they are not supposed to do if he had the proper, skill, training, and everything that he was supposed to be doing. So on the negligent entrustment, I think there's some evidence of that, because we have testimony in the case and then statements. And then as us not having any evidence of negligent hiring and all of those things, like we just discussed for the last hour or so, I don't have any of those documents of their policies or how they trained him. So yeah, you can say I don't have any evidence of it, but I don't have any evidence of it because they haven't given me any of the documents I think I'm entitled to.
I'm going to push this until after the plaintiff has an opportunity to review the discovery and do further discovery on those issues. So, anything else, guys?
No, Judge.
All right, guys, be safe out there and have a great weekend, okay?
All right, thanks, Judge. Take care.
Happy Easter.
Bye-bye.
Yeah, happy Easter, everybody.
And make sure make sure you get me a happy Easter. Make sure you get me an order on all of this, Ms. Jobin.
Okay, I will.
Okay. Thanks, guys.
Thanks. Bye.
And that's it for today, Tony.
Okay.
We have, and check with Rhonda. A lot of our hearings on, we sent you a bunch of Zoom notices, or she should have sent you a bunch of Zoom notices for Monday. Some of those have been canceled, so you might want to check with her to make sure we have, we're completely up to date. I think it looks like we have, you might want to write this down, we have a 9 o'clock on 198724. That's still going on. We have a 10:05 on cause number DC 1716679.
Okay.
At 1:30, we have a Zoom hearing on 1815106.
Okay.
And then we have a Zoom hearing on DC 199922 at 4 o'clock.
Is that a
the
TI?
one we had? I'm sorry.
Was that a TI at 4 o'clock?
No.
Okay.
No, something else.
Okay.
We don't have that. That's actually a really interesting motion for partial summary judgment. We'll have some interns watching that actually. Now we could have cancellations between now and then, but I don't think that at least the 10:05 and the 4 are going to cancel. But but we did have one for 10:30 that did cancel already. So anyway, just FYI.
Okay.
And try to sign in at least 5 minutes beforehand, because we're kind of getting delayed. You're showing up right when the hearing starts and you're having some lag. I don't know if it's your Wi-Fi or whatever, and it's delaying the hearings. And on Monday especially, we're going to be very busy. So try to sign up to each Zoom hearing if you can 5 minutes in advance.
Well, actually, so I do like 2 or 3 minutes. And so like I'm in and it says that I'm waiting in the virtual room. I don't know.
I don't, you're the only person I'm having that issue with. So the last couple times you've applied you've joined, and then I admit you and it won't let you in the first time. And then you come up again like 3 or 4 minutes later with a different, I don't know if you retry, and then I'm able to let you in. So that's why I'm saying there's something wrong with your Wi-Fi or computer connection or something, because I'm not having that issue with anyone except for you. So let's try to get there 5, maybe even 10 minutes before we start so we don't get delays, because we're getting delayed almost every hearing because because of that issue.
Yeah, but I've been trying. So I'm short of getting another computer. I mean, I don't know, but I'll try it.
Well, just get here earlier so if we have that issue, we can deal with it, because I think there's some kind of delay. I don't know what it is either, but it's taking longer for you to get in, and then you're showing up right beforehand, and so it's delaying almost every hearing. It wasn't a huge deal today because we just have one Zoom hearing, but on Monday, there are going to be time periods where we're just going to be stacked up. So I just need you to be there earlier.
Okay.
Okay.
I'm trying. Okay, Judge.
All right. Thank you. Bye-bye.
Bye-bye.